The challenges of establishing international space law for colonization are profound and multifaceted, involving legal, ethical, political, technological, and economic complexities that transcend the traditional boundaries of terrestrial governance. As humanity moves closer to establishing permanent settlements on celestial bodies like the Moon and Mars, the absence of clear and universally accepted legal frameworks poses serious risks to the peaceful and equitable development of space resources and territories. Current space law, most notably the Outer Space Treaty of 1967, provides a foundational framework that prohibits national appropriation of outer space and mandates that space exploration be conducted for the benefit of all humankind. However, this treaty and related agreements were created during the Cold War era, long before private companies and emerging spacefaring nations became major players in extraterrestrial activities. As such, they are increasingly seen as outdated and inadequate for addressing the realities of space colonization. One of the primary challenges is the ambiguity surrounding property rights in space. The Outer Space Treaty explicitly states that no nation can claim sovereignty over celestial bodies, yet it does not clearly address whether private entities can own or profit from extraterrestrial land or resources. This legal gray area has led to differing interpretations by countries and corporations, with some arguing that commercial exploitation of space resources is permissible as long as it does not involve claims of sovereignty. The United States and Luxembourg have passed national legislation allowing private ownership of extracted space resources, while other nations argue that such actions violate the spirit of international law. This lack of consensus threatens to create conflicts over resource extraction, particularly as technology advances and the economic potential of space mining becomes more viable. The involvement of private corporations further complicates the legal landscape. Unlike traditional state actors, private entities are primarily driven by profit motives and may not be bound by the same ethical or diplomatic considerations. While the Outer Space Treaty holds nations responsible for the actions of their nationals in space, it remains unclear how liability and enforcement would function in practice when a corporation engages in controversial or harmful activities beyond Earth. This raises concerns about accountability, regulatory oversight, and the potential for monopolization or exploitation of space resources by a few powerful companies. Jurisdictional issues also present a major hurdle. In the absence of a centralized governing authority for outer space, questions arise regarding which laws apply in extraterrestrial settlements and how disputes will be resolved. If multiple countries have citizens living and working on the Moon or Mars, and these individuals operate under different legal systems, the potential for legal conflict and confusion is significant. Some propose establishing an international space agency or tribunal with the authority to mediate disputes and enforce regulations. But such a body would require broad international cooperation and agreement, which has historically proven difficult to achieve in space policy. Another challenge is the equitable distribution of space resources and opportunities. Without a fair and inclusive legal framework, there is a risk that space colonization will exacerbate existing inequalities on Earth, allowing wealthy nations and corporations to dominate extraterrestrial territories and reap disproportionate benefits. The Moon Agreement of 1979 attempted to address this by declaring the Moon and its resources the common heritage of mankind and calling for an international regime to govern their exploitation. However, the agreement has been ratified by only a handful of countries and is not considered binding by most major spacefaring nations. This lack of participation underscores the difficulty of achieving global consensus on equitable governance structures for space. Technological and logistical realities also impact the development of space law. The fast pace of innovation in the space industry often outstrips the ability of legal and regulatory systems to adapt. Emerging technologies such as autonomous spacecraft, space-based manufacturing, and AI-driven exploration raise novel legal questions that existing frameworks are ill-equipped to handle. Furthermore, the physical distance and communication delays associated with deep space missions complicate real-time decision-making and enforcement of legal norms. This necessitates the development of flexible, forward-looking legal instruments that can accommodate rapid change while maintaining stability and predictability. Environmental protection is another critical area of concern. The establishment of human settlements on other planets could have profound impacts on extraterrestrial ecosystems, if such exist, and on the pristine environments of celestial bodies. Current space law provides only general guidance on the protection of space environments, with limited mechanisms for enforcement. As colonization efforts expand, there will be a growing need for robust environmental regulations that address issues such as planetary contamination, waste management, and the sustainable use of local resources. These regulations must balance the goals of exploration and development with the responsibility to preserve the space environment for future generations. Security and militarization also pose significant challenges. The peaceful use of outer space is a central tenet of international space law, yet the potential for conflict in space is increasing. The deployment of space-based weapons, anti-satellite systems, and military installations could lead to an arms race that destabilizes the extraterrestrial domain. Colonized planets or moons could become strategic assets in geopolitical rivalries, leading to disputes over control and access. Establishing clear legal norms and confidence-building measures is essential to prevent the escalation of tensions and ensure that space remains a domain for peaceful cooperation. Cultural and ethical considerations must also be addressed. The act of colonizing other planets raises profound questions about humanity's role in the universe and our responsibility to future generations. Who gets to decide how extraterrestrial settlements are governed? How will diverse cultural values and beliefs be represented in space law? These questions highlight the need for inclusive and participatory processes in the development of legal frameworks, ensuring that all voices are heard and respected. Historical precedents can offer valuable lessons. The colonization of new territories on Earth was often marked by exploitation, displacement, and conflict. To avoid repeating these mistakes, space law must be grounded in principles of justice, cooperation, and sustainability. This includes recognizing the rights and interests of all humanity, not just those with the technological and economic means to reach space. It also involves creating mechanisms for public accountability and transparency in space governance. Education and public engagement are vital for building support for international space law. Many people remain unaware of the legal and ethical implications of space colonization. Raising awareness through education, media, and public discourse can foster a more informed and engaged global citizenry. This, in turn, can pressure governments and institutions to act responsibly and collaboratively in shaping the future of space law. International cooperation is both a challenge and a necessity. Space activities increasingly involve a diverse array of actors, including emerging space nations, commercial ventures, and multinational consortia. Developing legal frameworks that accommodate this diversity requires trust, dialogue, and mutual respect. Bilateral and multilateral agreements can serve as building blocks for broader legal regimes, while existing institutions such as the United Nations can provide forums for negotiation and consensus building. The role of soft law and non-binding instruments should not be underestimated. Codes of conduct, best practices, and guidelines can help shape behavior and build norms even in the absence of formal treaties. These instruments are often more flexible and easier to adopt, allowing for incremental progress toward comprehensive legal frameworks. Over time, they can evolve into binding agreements or be incorporated into national legislation. National interests and sovereignty remain significant obstacles. Countries may be reluctant to cede authority to international bodies or accept constraints on their freedom of action in space. Balancing national prerogatives with the collective interest will be a delicate and ongoing process. Mechanisms for dispute resolution, confidence building, and verification will be essential to maintaining trust and cooperation. Economic interests also drive tensions. The commercial potential of space resources, from rare minerals to solar energy, creates powerful incentives for competition and unilateral action. Legal frameworks must address issues of ownership, taxation, benefit sharing, and market access to ensure that economic activities in space contribute to the common good rather than exacerbating global inequalities. The integration of space law with other areas of international law presents additional complexities. Space activities intersect with environmental law, human rights law, trade law, and telecommunications law, among others. Harmonizing these legal regimes and addressing potential conflicts will require interdisciplinary expertise and coordination among legal scholars, policymakers, and practitioners. Data governance and privacy are emerging concerns in the context of space colonization. As settlements and operations generate vast amounts of data, questions arise about who owns this data, how it is used, and how privacy is protected. Legal frameworks must establish clear rules for data collection, storage, sharing, and protection in extraterrestrial environments. Health and safety regulations for space settlers will be crucial. Prolonged exposure to microgravity, radiation, and isolation poses significant risks to human health. Legal standards must ensure that adequate medical care, occupational safety, and psychological support are provided for those living and working in space. This includes defining the responsibilities of employers, space agencies, and host governments. The potential discovery of extraterrestrial life adds another layer of legal and ethical complexity. If life is found on other planets or moons, how should it be treated? Should it have legal protection? How would this affect plans for colonization and resource use? Existing legal frameworks offer limited guidance, underscoring the need for precautionary principles and adaptive legal instruments. The development of legal identity and citizenship in space will also need to be addressed. As permanent settlements emerge, questions will arise about the legal status of individuals born or residing in space. Will they hold Earth-based citizenships, or will new forms of political and legal identity be created? How will rights and responsibilities be defined and enforced in these contexts? Language and communication barriers could hinder the creation and implementation of international space law. Effective legal frameworks require clear and consistent terminology, as well as mechanisms for translation and interpretation. Ensuring that all stakeholders can understand and engage with legal texts is essential for legitimacy and compliance. Timeframes and urgency present a final challenge. The pace of technological development and private sector investment means that colonization efforts are likely to proceed with or without comprehensive legal frameworks. This creates pressure to act quickly, but rushed or poorly conceived legal instruments could lead to unintended consequences. Balancing urgency with thoroughness and inclusivity is a critical task for the global community. In sum, establishing international space law for colonization is an immensely complex endeavor that demands visionary thinking, global cooperation, and a commitment to shared values. The stakes are high, as the decisions made today will shape the future of humanity in space for generations to come.